Welcome to the Orlando Sentinel's editorial board interview with candidates for the 9th Judicial Circuit Judgeship in Group 43. In this race, Stephen Brown will challenge incumbent Craig McCarthy. And with that, Chris Fluker will begin us with our first question.
Thank you very much. One of the phrases that we often hear when we are talking about judges and judicial candidates is the phrase judicial temperament. And it is considered a very important but very difficult to define quality. And I would just like each of you to give us your philosophy on what qualities a good judge should have. And let's start with Judge McCarthy.
Good morning. Thank you very much. By the way, Orlando Sentinel Editorial Board, thank you for hosting this, and I appreciate that question. I had the great pleasure and the opportunity, to witness very, very good judges over the years. Before I was on the bench, I made the bulk of my career in juvenile law. And like some other areas of law as well, you're dealing with people in crisis. So kind of baked into the cake is that you're going to see people in the courtroom who are having a very bad day or a very bad week, month, or year. And I had the example of seeing really good judges deal with people in crisis. And I, as an attorney for those people in crisis over the years, got to know how to relate to them, to see them as people, to humanize them before the judge. And that helps to calm things down in the courtroom and get people back on track, which is problem solving. Now, I've been on the bench a year as a general magistrate. That was in juvenile dependency, so I heard cases of child abuse. And in my 2 years as a circuit judge, I'm on the family bench. Again, it's people who are otherwise good people going through what could be the most difficult time in their lives. So those are the touchstones or the understandings I have and the experience that I've had to know that patience is number one. I remind myself every day to go into the courtroom wanting to maximize and asking for wisdom, patience, and humility. To understand that I'm dealing with hurting people, a judicial temperament is one that is slow to decide and very quick to listen and is very patient. Thank you.
Okay, Mr. Brown, same question.
Thank you for having me. I believe one of the most important things that a judge should have in their temperament is a sincere and honest belief in the court system, in our Constitution, in our statutes, and the power of the courts. On top of that, I believe that judges should listen more than they speak in the courtroom. They call it a hearing for a reason. You're there to be heard, not to be lectured. Judges, of course, should be patient with attorneys and pro se litigants, but they should be decisive. Unfortunately, in my career, a few times I've had cases that I just could not get to trial because the judge would not set a trial because the judge did not want to make a decision. And nobody's helped when a judge is kicking the can down the road. I've been blessed to try cases in front of many judges. I've seen what I think works, and I will implement all the best qualities of all the many judges before whom I have practiced.
Thank you for that. I have a question to jump in on. I know a recent decision by the Florida Supreme Court could weaken the restrictions on what judges can say about their political or partisan affiliation. What's your view of this decision, and will it change the way you campaign? And let's start with Mr. Brown.
The Supreme Court's ruling is the law of the land, so I don't necessarily think that my opinion is all that important. I'll follow it whether I like it or not, full stop. That is actually something that differentiates me from my opponent. In his 147-page book, he managed to disparage the Florida Supreme Court, the U.S. Supreme Court, the Massachusetts Supreme Court, and the California Supreme Court as activist judges because they made rulings with which he disagreed. The legitimacy of our courts is paramount to the success of our democracy. My opponent has advocated the executive and legislative branches ignoring court opinions with which they disagree and defunding the courts, quote, turn the lights out and stop paying for court staff. He published a platform encouraging all of his followers to run for office to implement these ideas, and he himself actually unsuccessfully did run for office to implement those ideas. My political beliefs will have no impact on my legal interpretation. To answer the second half of your question, I've been campaigning since June 1st, 2023. That's over 13 months. I have built support across our community without discussing my personal political preferences, and I don't see any reason to change that. At this point, with mail ballots going out in just 9 days, we're kind of in the home stretch there. I have made sure to make myself available to voters from Kenansville all the way to Winter Garden and everywhere in between. And I'm confident that the voters will make the right decision to elect a candidate that is an experienced lawyer and respects and understands the essential role of the courts in our democracy.
Thank you very much. Judge McCarthy, I'd like to give you the chance to respond and also to answer the same question.
Well, I will answer your question, and I thank you for that. I took to heart your instructions at the beginning, and I'm not treating this as a debate. I did write a small book 20 years ago as a private citizen, as a lawyer, long before I ever thought I would be on the bench. And the purpose of it, whether one agrees or disagrees with my analysis in the book, the purpose was it to have a strengthened judiciary, a functioning judiciary, one that follows the law. I believe that Mr. Brown mischaracterized or misunderstood a lot of what he just said, and that's all I'm going to say about that. As to the answer to your question, Mr. Brown is correct that my opinion of the Florida Supreme Court's opinion is not important because they've made the decision. It was in the context of discipline, potential discipline of a judge for campaign conduct. And the decision stated that it did not encourage that candidates or judges who find themselves to be candidates state whether they are conservative or liberal. It simply said that the court found that stating that one is one or the other is not a disciplinary level event. And that's a very different analysis from saying you should do this. I don't think we should. The decision is interesting, and it was interesting to read, but it wouldn't change anything that I've done. I need, when people enter the courtroom in which I preside, I need for them not to be wondering, what team is this fellow on? I need people to come in seeing the trappings of the courtroom and the robe and think, I'm going to be treated fairly. So I do not bring partisan politics into my role as a judge or into the campaign that we're running.
I'd like to follow up on that. And I do thank you, by the way, for remembering that we really want to address both of you, your independent views and the way that you would handle situations if elected, instead of kind of taking shots at each other. I would really appreciate that. But one of the as we know, circuit court is the higher of Florida's two trial courts. And circuit judges are required to pass judgment on issues that are extraordinarily high stakes. Everything from the fate of a family, to lawsuits involving millions of dollars, are felonies that could demand the death penalty. And these are all issues that many of us have strong personal beliefs about, or faith traditions that tell us how we should act in these cases. But a judge is called upon often to set those aside. How personally is the best way for a judge to reconcile those personal beliefs and traditions with these very, very difficult decisions that they have to make. And let's start with Judge McCarthy.
Thank you. When one takes the bench, one makes a very pointed decision to sublimate personal beliefs. And the only way you can find out if someone lives up to that is by observing them. And I've been on the bench now for a little while. And there, for instance, there's been changes, dramatic changes in family law about the presumption of time sharing in the last couple of years. And so I find that by following the law, I quite often actually issue rulings that I personally think might not be the best idea. But the comfort of being a judge is that as much weight, and you mentioned the responsibilities of a circuit judge. I mean, a circuit judge potentially can have someone's life in his or her hands. I've not done any death penalty cases, but potentially one day. As a family judge, I do have people's lives, in a sense, in their hands, at least the trajectory they're going to go on. So I'm very cognizant of all that weight of responsibility. And one comfort for bearing that weight is that it really isn't on me. It's for me to look in the statute and the case law that interprets the statutes and do what it tells me to do. That is a comfort, helps me to make decisively the decisions that I need to. But to your question, I can tell you, that happens all the time. There are things in my head, or even sometimes in my notes during trials, I think, I don't like what I'm going to have to rule here, but I do it gladly because that's what I pledged and swore an oath to do for the people of the Ninth Circuit.
Thank you. Thank you. Mr. Brown, same question.
So the law and the Constitution are paramount to any decision that a judge should make. As a criminal defense lawyer, I've had to take many positions in my life that I have disagreed with, but I've always followed the law and held the state to its burden following the law. And I don't think I would have any difficulty continuing that on the bench. In fact, I'm sure I would not. Being a lawyer, there's a lot of compartmentalization involved, especially when you have clients that are disagreeable. So I think in my 17 years of practicing criminal law, I have, and actually family law too. They say that in family law, you see good people at their worst, and criminal, you see bad people at their best. But anyhow, when I represent a client, I focus on the facts and the law, and I believe that's what the judge in any particular case should do.
I have a quick follow-up to that that's sort of related and probably can be answered quickly. Sort of related to that is the subject of recusals. I know that recusals often happen in the case of personal knowledge of a litigant or something like that. Are there any cases beyond that you feel the need to recuse yourself or to issue a recusal? And Mr. Brown, we'll start with that. We'll start with you.
Sure. You're absolutely correct. This is a short and easy answer. There is a procedure for disqualifying a judge. And then there's also recusal, which is where a judge feels in their heart that either they can't be fair or there may be an appearance of unfairness. So in an instance where a judge has that feeling himself, then he or she should always err on the side of recusal. And in my opinion on disqualification, of course, the procedures have to be followed. They're very well outlined in the rules and statute. If there's any doubt in a judge's mind whether the motion is legally sufficient, which is the standard for a first-time disqualification, then I think that the correct thing to do is err on the side of disqualification, because at the end of the day, the legitimacy of our court system in the eyes of the citizens is of the utmost importance.
you may not be able to answer this in your position, but can you think of anything personally that would cause you to recuse yourself?
And that question was directed at me, I believe.
I actually wanted to follow up with Mr. Brown for just a moment on that one. If there was anything that you could think of personally that would cause you to recuse yourself from a case.
If you're asking, are there facts or social issues that may cause me to have some sort of prejudice either way, I'm very confident that is not a concern for me. As I mentioned, I'm very good at compartmentalizing. However, in real life, there are relationships and there are people that perhaps I don't trust, or they don't trust me. And in that case, I would certainly err on the side of recusal, because again, it's not about me or the perception of me. It's about the court and the legitimacy of the court in the eyes of the citizens.
Thank you. And Judge McCarthy, I know I asked several questions in one there. I'll give you a little bit of extra time to respond.
Sure. Thank you, Mr. Reddick. Well, I have granted motions to disqualify. I've done that twice. I think the first time, I think I had my feelings hurt a little bit, and my very wise chief judge counseled me that this is part of what we do. It's not personal. So first of all, the foundation principle is that a judge cannot do anything to damage the perception and the belief in the impartiality of the court. That's the principle. So if there's a possibility either through a sufficiently pled motion to disqualify that's at play, it isn't personal. I don't have any problem granting those, with the caveat that if one is not legally sufficient and you believe that someone is what we call forum shopping or judge shopping, that's inappropriate. So we have to be vigilant about that. Recusal is about being transparent, making sure that if there are any relationships or even by a degree or two of separation between any of the litigants, any of the attorneys and a judge, I'm always very transparent. I recuse from things often because I've got a long history as a defense attorney in the juvenile court. And there's a lot of crossover between family cases and juvenile cases. So I recuse myself from time to time just because I always do a conflict check. Same thing if I believe that I've had a long-standing professional relationship with an attorney who is appearing before me, and especially if it's a pro se litigant on the other side, I'm always careful to disclose. I want you to know how I've worked with this person in the past and make sure that's okay with you. So recusals are about being transparent and making sure that the judges do nothing to damage the perception of fair and impartial justice.
Thank you. Thank you so much. The next question I wanted to ask, and obviously, again, this is going to vary given your experience, but one of the other cliche sayings that happens to be very true about courts, and particularly family court, because you're dealing with children who are growing and changing, sometimes right in front of your eyes, is that justice delayed is frequently justice denied or disturbed. And I wanted to know how you manage a significant caseload with efficiency while still understanding that they're human beings. But what ideas have you implemented, Judge McCarthy, or would you like to implement, and that would go to either of you, to make this division run more smoothly? And we'll start with Judge McCarthy.
Thank you, Ms. Fluker. There are resources that we have, but the backdrop of this is that, as we all know, Central Florida's population growth has outpaced the addition of new judges in the Ninth Circuit. All of that is public policy. It's a legislative matter and far above my pay grade, but it's a reality. And so it makes it a challenge. So what I have done is I've engaged we've got case managers who work out of the self-help center who are an amazing resource. And I have established good personal relationships. We meet with them regularly. They're in contact with my office weekly. And I've got a very vigorous, what we call uncontested docket. So what we do is we triage cases, find the ones that are relatively simple, that can have a simplified dissolution of marriage, a divorce, for instance. And we really stay on top of that. So twice a week, I start the day hearing a number of uncontested matters, and I keep increasing the numbers of those. So that takes them off the docket so that everything else that's been waiting and is more complicated has a better shot at getting time with the judge. I've also have a very good relationship with our general magistrates. In fact, the general magistrate who's assigned to aid me in my division used to be my boss. She was my supervisor when I was the general magistrate. So we have a very good relationship. And we've worked to, and she and the other magistrates are fantastic at their job. So I utilize that. And beyond that, we just work very hard. I inherited, shouldn't say inherited, I took over a division that had a significant backlog, and we just worked like crazy to get that under control. So I'm dedicated to that. It is a challenge, but I've done those things and continue to identify things that can help reduce wait times for hearings. We've been very successful so far.
Thank you so much. Mr. Brown, same question. What would you like to implement that would make this division run more smoothly or efficiently?
One of the most important things that we can do to increase efficiency in every division, particularly in the family division, is removing a lot of the red tape, for lack of a better term, that it takes to even get to trial, which I believe it's a lot of paperwork and a lot of billed hours to clients who can't afford it. And I believe if we could get rid of a lot of that, then we could focus on resolving cases quicker. I do agree that our circuit has been starved for judges. Last year we had 4 vacancies for the majority of the year. And then finally, after the cutoff period for this election, the governor decided to appoint 4 judges to fill those vacancies. But we do not see, and again, this is, I agree it's more a public policy thing, but judges do have to advocate for their courts. And we do not see the correct number of judges being assigned, particularly in Osceola County, which I feel is extremely neglected compared to Orange County. Osceola County needs at least 2 more county court judges. As I understand it, the county court judges are covering criminal, traffic, small claims, and everything else in between. So to be more efficient, hopefully at some point we will get more judges to assist with that. And finally, I think that courts should be open 5 days a week. Some judges, including my opponent, apparently don't have court on Friday. And I believe that if court was held 5 days a week, many more decisions could be made quicker for the people that are relying on them.
Thank you. And since you mentioned your opponent, we would like to allow a brief response.
Okay, thank you. The majority of the domestic relations family law judges schedule into their calendars writing weeks for administration or administrative weeks, because for every hour we spend in a courtroom in a trial or a hearing, we need 2 to 3 or sometimes more hours to write. And we all do it on the weekends. We all do it in the evenings. What I have elected to do, instead of blocking out writing weeks, is take the equivalent amount of time. Instead of having a writing week per month, I have a writing day per week. Mr. Brown has never asked me about why I did that. It's very efficient. And the wonderful thing about it is I've got in my back pocket for the emergency motions that I get in throughout every single week. I always know that I have time, and I can tell my JA, we'll hear it Friday. We'll hear it Friday. So that is a mischaracterization of the procedures in my court.
Thank you. Okay. And then I wanted to ask, actually, Mr. Brown, did you want to respond briefly to that, or?
No, it's not necessary.
Okay, thanks.
I stand by what I said.
Thank you.
Chris, I can jump in. I wanted to ask you both about resources. I know that litigants and defendants here there's been a question of whether there's adequate access to resources, including translation for different languages, interpretation. Sometimes it's about adaptive technology for people who are visually or hearing impaired. And I wanted to know what your thoughts were on that, and what resources could be used. How would resources best be used to help those issues? And Mr. Brown, let's start with you.
Now, I want to characterize this as my personal opinion. Again, resource allocation is actually not within the court's power, and it's actually a political question. So my personal opinion is that translation should be a right in courts, in all divisions of the court, not just criminal court, at least in Spanish. And that's because here in Central Florida, we have a huge Puerto Rican population, and they are just as American as those of us who are born on the mainland. And yet we ask them to go to court and either pay for their own interpreter at $2 whatever an hour, or try to stumble through it with English as their second language. And quite frankly, we're in the year 2024. I think that there are solutions for this. With regard to other languages, I believe that within reason there should be resources available. Perhaps translation for a fee that is less than the market cost of a translator. I mean, if you look at the Florida driving test, it's offered in 6 different languages. And why are we offering the driving test in 6 different languages, but we're expecting people to come to court and all conform to one language? I think in many cases, the risk is higher coming to court and not understanding what's going on versus the driving test, which could be taken multiple times. With regard to hearing impaired and other disabilities, I think that those fall soundly within the ADA, and I think that the court must, and I think our court, Ninth Circuit, is very good, must provide accommodations for those.
Thank you. Judge McCarthy.
We certainly could and should have forms available in more languages. I don't think that's controversial at all, and that's an ongoing project. I don't think it's controversial also to say that we need more access to language interpreters. When we know that it can be done, and in the criminal divisions and in the juvenile divisions, it's at the press of a button, and it works mostly seamlessly for Spanish and Haitian Creole, at least. And I got used to that when I was in the juvenile courthouse, and I've certainly used it on weekend duty at the jail at first appearances. So we know that we can do it. It's just not spread to all the other divisions. What I do often, if it's not a trial, and if it's not a particularly contentious matter, it's just a matter of making sure that people understand what is happening, and that making sure that people have their due process rights respected. I very often allow family members and friends who are not certified court interpreters to sit in. And so sometimes we just have to slow down and have a discussion. And, if I think, well, things probably aren't being translated, I get the sense accurately, that's one thing. But we do that often, just to keep things moving and to make sure that people's trip to the courthouse has not been wasted. Thank you.
Thank you both so much. We have actually gotten pretty close to the time that we've allocated for this interview. In a few minutes, I'm going to give you both the opportunity to make a wrap-up pitch as to why you should be the voter's choice in this race. But first, I would like to remind our readers, we will be making an endorsement in this race. However, we end every interview by saying we don't want that or expect that to be the only thing that you look at when you're making decisions. As we've talked about today, judges have tremendous power over the lives of the people who appear before them, and the lives, the fortunes, the families, and we think that there are many resources out there that you can use to decide which candidates most represent your values and your expectations of our court system. So we urge you to look at both of these candidates, and we thank them very much for taking the time to talk with us today. There's always a reason we start with judicial candidates, because they are some of the most interesting interviews. So we will start with Mr. Brown, if you will give us your 2-minute wrap up as to why you think that you would be the best choice in this race, and please keep it basically to yourself, and what qualities you would people can expect to see from you if you're elected.
Thank you. I have been reading the Orlando Sentinel for a long time, including the endorsements, and I believe the precedent is that I have to answer 2 questions, and those 2 questions are, should the incumbent be replaced, and why am I the person to replace him? So while I appreciate your instruction, I would ask for the opportunity to address those 2 questions, as those often appear on the pages of the Orlando Sentinel in endorsement articles. Based upon my opponent's history, his advocacy against the courts, to defund the courts, and his criticism of nearly every civil rights case in the last 70 years, I don't believe that he represents our values in Central Florida. I mentioned he wrote a 147-page book, but when he decided he wanted to become a judge, he started calling it a pamphlet. He called it a pamphlet in his judge application. He called it a pamphlet on the campaign trail. But when he was selling it, he called it a book. On his website, he called it a book. And he did mention that it was 20 years ago. It was a little less than 20 years ago. But he kept it online up until the time he became a judge, with a little disclaimer saying that the material is dated, but the principles are correct. So it's not a matter of he made a mistake a long time ago. This was something that he advocated for years. 2 months after becoming a judge, he applied to be elevated to the appellate court, and he did it 2 more times within his first year. Unlike my opponent, when I'm elected, I plan to stay here in Central Florida and serve the people of my community. I don't see this as a stepping stone. I have practiced law here in Central Florida for 17 years as a prosecutor and in private practice. I'm the only candidate in this race that has ever tried a case in front of a jury. I'm also the only candidate in this race that has any criminal law experience, which is very important to our community. At some point, I have appeared at every division in the circuit court. I believe in our court system, and I believe that I am the better candidate in this race, and I believe that the voters will agree with that, and I hope to earn your endorsement.
Thank you very much. Judge McCarthy will allow you a little extra time as well. So if you want to tell us why you think you're the right choice in this race.
Mr. Reddick, Ms. Fluker, members of the Orlando Sentinel Editorial Board, and everybody who's tuned in to watch this, thank you. Particularly those who have tuned in to watch. Judicial races are difficult. It's very hard. I know this as a lawyer. People over the years come and ask me, who do I vote for? So you are the ones who are making sure that you are informed. And so a special thanks to you. Anybody who wants to know more, please go to keepjudgemccarthy.com, keepjudgemccarthy.com. It's got a link to our Facebook page. We'd love to hear from you. Two of the I think, key, anyone who has a bar license can learn the evidence code, can study and learn the law. I think the demeanor to be a judge is something that cannot be taught. I think what two of the key components of being a good judge is reading comprehension, a sense of one's own fallibility, and not to prejudge matters or people who we don't truly know. I think that we just heard an example of reading comprehension problem and of prejudging someone that he does not know. But about me, I've been tested on the bench for the past 2 years as a circuit judge and year as general magistrate. I've been tested, I've been seen, I've got the enthusiastic support of the family bar, most of them, who appear before me. They like me, they like how I conduct myself, and they want to keep me on the bench. My ethos of how I apply myself to professional matters was formed throughout my life. It was really solidified and internalized when I was 17 years old and I joined the Army. I became a cadet at West Point. One of the first things we were taught is that the United States Military Academy exists. Its mission is to prepare leaders of character for a lifetime of service. I've internalized that ethos. With my wife, who's a master of social work and a fantastic research, I've made a career out of representing the vulnerable and people who need help, who need to be humanized. I cherish and respect and am humbled by the trust that's been placed in me. It's the most serious thing I've ever done in my life. As to applying to the 6th DCA, I did that because I was asked to, because the 6th DCA was brand new. And people asked me, Craig, can you join other respected jurists as applicants so that the public can be sure that this is a good process? Thank you again for listening to me. It would be an honor to me if you would consider voting for me. Take care.
And may I respond
Thank you very much.
May I respond to the reading comprehension statement?
Briefly, very briefly, please.
All I have to say is, with regard to reading comprehension, I don't know how else to read it when my opponent describes Brown versus Board of Education as the Supreme Court attempting to stumble through tortured reasoning.
All right. And Judge McCarthy, did you have a response to that, or?
Well, there's more to that sentence. He read half a sentence, and I don't want to go back and forth. I've really enjoyed the insightful questions that you've given me. But the point of that chapter was that Brown was something that never should have been needed. What I wrote is that the court in Plessy, the separate but equal doctrine, gave legitimacy to every bigoted attitude held by unjust public officials. And I went on, and I lamented that Brown versus Board was ever necessary. The other half of the sentence he just read, court attempting to stumble through tortured reasoning to clean up one of its own mistakes, meaning separate but equal in Plessy versus Ferguson. And that's what I meant by reading comprehension.
Thank you. Thank you very much.